Welcome back to the Legal Alternative podcast with me, Sam Pawson. I am flying solo this week, so no Nils this week. He is in court as we speak, so he's had a 3-day court hearing. So sadly, we've got no Nils this week. So just a quick update from me. I just wanted to update on a case, and it's got some court attention. So I've got my notes here. So it's a case being reported in the press. The kind of headline and grabbing press articles have talked about a case where an employee who has been told that she looked very Aryan has received £18,000 in the tribunal. So as always on the Legal Alternative, just going to unpick that a bit and actually what are the facts, where are the headlines maybe misleading, and as always, where can companies and listeners learn from these cases. So background of the case, actual case involving claimants Guy Sinclair and a pub in Glasgow. So it's actually a Scottish case, but the law is still good in the English Employment Tribunal against a pub called the Old Tull Bar in Glasgow. Employee short service, less than 2 years, subject to a number of remarks from the director of the company, named a chap called Ahmed Magdi Solomon, who made the following remarks to the claimant in and around the summer of 2023. So first one, again, which grabs the headlines, is that the claimant, look very Aryan with your blue eyes and blonde hair. Again, reports throughout the tribunals at all times, claimant felt uncomfortable. A few weeks later in the chronology, after the claimant had brought a coffee for a white colleague, the director said, "Is that for me?" And on learning it was not, added, "Oh yeah, I forgot you like white people better. How was Germany?" Again, the claimant has no connection to Germany at all, and again reports how the claimant felt uncomfortable. After that, there was some facts how the claimant was then removed from a group WhatsApp chat, and shortly after called into a meeting where her employment was terminated on the grounds of the company saying there was poor sales performance and therefore inadequate resource for the claimant to be employed. Claimant then brings a claim in discrimination. As I say, this is a case where we've got less than 2 years service, so can't be challenging in bringing an ordinary unfair dismissal claim. So the claim is in discrimination, again on the grounds of race. So judgment held in the tribunal that the claimant was discriminated on the grounds of her race. To kind of go further into that, it's as well as the form of discrimination is in form of harassment. So the judge ruled that the claimant had been harassed and unlawfully discriminated against Mr. Solomon's unsolicited and race-related remarks, added that the business owner's comments on Miss Sinclair's race and appearance put the bar manager in a difficult position, and there was no evidence found of any misconduct or any reason that could have terminated the employment. So therefore, the reason that the court and tribunal held was the dismissal was connected to the individual's race. As a result, the tribunal makes quite a low injury to feelings award, £2,000. So we're in the lowest vento bracket there. But critically, was awarded £14,000 in connection to loss of earnings. So when we always talk about discrimination claims, we do look at obviously injury to feelings, which is the award for the actual act of discrimination. In this case, obviously the comments about Miss Sinclair's race. The key here is that the dismissal itself is found to be discriminatory. Therefore, earnings and loss of earnings will run from the dismissal. And as I say, in this case, around £14,000 as a result. Finally, in connection, there was an additional award for the company failing to provide written reasons for the dismissal and notice pay, which was another £1,275. So we're looking at compensation in total around £18,000. So takeaways is from these cases, as always, less than 2 years employment, so no unfair dismissal. That does not just mean you can dismiss for no reason, especially when we've got clear cases of potential discrimination. So we look at these cases where we have offensive remarks. Here, whether the manager and director in this case meant to discriminate, it's not really critical. Obviously, in these cases, the intention doesn't matter. It's the purpose or effect of those comments clearly cause offence to this individual. So clear findings that, as you know, as companies, we need to guard against those kind of comments. When they are made, take some action against them. Clearly a case here that hasn't been done, and therefore we're looking at £18,000 worth of compensation. So quick update from me this week, just on those cases. Had some quite wide press reporting. We will be back next week with Nils in tow. Turns out the office, I did mention seminars. Again, I'd look on the website on the Chadwick Lawrence UK and our events and seminar page. Special would alert you to our mock tribunal, always the highlight of the year, which is coming up in the next few months. Back next week with Nils. Thank you for listening.